us live today. But let me just take this opportunity to welcome everyone back. We're here in our now third session. This topic is about preliminary issues that happen during the arbitration. As you know, we've been following the life cycle of an arbitration. And with us today are two formidable law firm practitioners who have been in practice for many years and have worked in domestic and international cases, and will be a tremendous insight for us on these preliminary issues that happen in the course of an arbitration. I'm going to go ahead and turn it over to Paul Hines, partner at Jones Day, and Carla Gharibian, who is an associate at Jones Day, for them to introduce themselves and to delve right into the topic. As usual, your questions are welcomed. I will be kind of in the background here moderating. I'll look out for any hands raised or any questions that might have come in through the chat, and we'll try to get those questions answered and keep it interactive. So I'll turn it over to Paul and Carla to lead our discussion today.
Thanks, Ghada. Hi, everybody. Really happy to be here. As Ghada said, my name is Paul Hines, and I'm a partner in the global disputes practice at Jones Day. I'm located in San Francisco. And just to give you a kind of brief overview quickly of what my practice is like, our global disputes practice at Jones Day really covers a broad array of topics. It includes litigation really anywhere around the world outside of the US, as well as litigation in the US that has substantial international and cross-border aspects, as well as international arbitration. And my practice throughout my career has probably, I would say, been 75% maybe roughly international arbitration, with the remainder US litigation with international aspects, and then international trade issues and those sorts of things, with some domestic arbitration sprinkled in here or there, often on behalf of US interests held by foreign clients. So I've been with Jones Day. I started as a summer associate in 2012 and have been here now since I finished law school in 2013. And I'd like to introduce Carla Gharibian, who's worked with me since she joined us, now 7 years ago, isn't it, Carla?
Yeah, somehow 7 years ago.
Hard to believe.
It is. Hi, everyone. My name is Carla Gharibian. I'm a senior associate in Jones Day's Global Disputes Group. I initially started in our San Francisco office, where I met Paul and got introduced to international arbitration just generally. I think, like many American practitioners, I had a sense of what that looks like, but it wasn't until actually beginning my practice after law school that I really gained exposure. Like Paul, I had exposure to international arbitration, whether it's commercial or investor state. Our firm also does a lot of civil litigation that has some sort of international nexus. And I also do a bit of sanctions work, especially earlier in my career. I'm now located in the Los Angeles office. We have a smaller global disputes team there, but also doing similar work, including more domestic arbitration these days.
Great. Well, so, we understand generally that the purpose of this program is to give you an opportunity to, get information from people who've been practicing in this area that's going to be helpful to you as you try and, embark on or further develop your careers in arbitration, and in particular international arbitration. So, with that in mind, we're going to try and keep things, fairly loose and interactive. Carla and I did prepare our own internal notes and sort of, agenda for things we can cover, but we're certainly open, to whatever is most helpful and most of interest to you. That having been said, the topic of today's session is on preliminary challenges. And, what we, think of within the scope of this is really the sort of kind of threshold issues that arise at the usually at the outset of an arbitration, but not always, that deal with fundamental questions like, does the arbitrator or tribunal have the power to hear this dispute? Can the claim actually be heard and adjudicated in arbitration? Who are the proper parties to the arbitration, and can the parties that have been brought into it actually be required to arbitrate? And at times, what are the actual operative contracts and disputes and claims that should be heard in a consolidated arbitration? So these are not necessarily the exclusive sort of issues that come up, but they are very common ones that come up in our experience. And so we thought it would be helpful to talk through them. And of course, during the course of this, we'll talk about some of our own case experiences, and I'm sure we'll get diverted to talking about other things that are of interest to you. So let me just start by by kind of orienting us in the process. So our understanding is that there's a lot of different levels of experience here with respect to arbitration and the arbitral process. So some of this, may be very basic for you, but our hope is that it might be helpful to some of you to just sort of orient, where we're sort of talking about in the timeline. So we understand that your first session was really about the arbitration agreement. So before you even actually get to arbitration, what sets the framework that actually puts you into this mode of dispute resolution? So when you have an arbitration agreement and a dispute arises, the way it starts is generally the way any case starts. It's with somebody filing, a pleading. In this case, it's generally a request for arbitration. Under some rules, they're called an arbitration demand. And then with that, the process sort of unfolds. And one of the early issues that arises is obviously, the selection and appointment of who's going to hear the proceedings. And we understand that was the topic of your second session, which is, how do you appoint members of the arbitral tribunal and what sort of issues arise? So, along that lines, as the dispute is unfolding, and it can come up as soon as the answer to the request for arbitration, or sometimes in the preliminary procedural discussions, that usually culminate in a procedural teleconference. There are often these fundamental questions about the nature of the arbitration and the power and scope of authority of the arbitrators that come up. And those are the things that we're really going to talk about here. And as we'll discuss, sometimes they get resolved early on as a threshold matter, but not always. These things can stretch on throughout the arbitration. So with that, I'll turn it over to Carla, who's going to start talking about one of the most common threshold issues that you see in arbitrations, which is a question of jurisdiction.
Thanks, Paul. At the outset, it's worth noting that in California, as anywhere, there are two flavors of arbitration. We have an international and we have domestic, of course. Given the nature of this mentee base, CalArb's focus on international arbitration and our respective practices, we'll be focusing on international arbitration in this presentation. Now, as you're likely aware, unlike courts, arbitral tribunals have no inherent power of jurisdiction. Their authority arises from the parties' contract, albeit once a contract is selected by the parties, it has the backing of statutes and treaties. Notably, arbitral tribunals can rule on the question of their own jurisdiction before intervention by national courts. This principle is known as competence and is well established in international arbitration and accepted in many national laws. In most arbitration regimes, an objection that the tribunal lacks jurisdiction must be raised no later than the time that the objecting party takes its first step in the arbitration to contest the merits of the matter. As Paul previewed, that may be in the answer to a request for arbitration. Now, there are a number of common jurisdictional challenges that may arise in international arbitration that both Paul and I have encountered in our careers. First is whether the arbitration agreement itself even exists, which may seem like a straightforward question, but surprisingly is not always the case. For example, a party challenging jurisdiction may argue that the contract it had entered into did not contain an agreement to arbitrate. Arbitration agreements are usually contained in the main contract between the parties, but sometimes an arbitration agreement is contained in a distinct and separate document, which is incorporated by reference into the contract between the parties. Some examples of this include references to general terms and conditions, previous agreements between the parties, or standard form contracts. The incorporation of an arbitration agreement by reference often raises two important questions that arbitrators must examine. These are the questions of 1, whether the reference is clear and sufficient to imply consent to arbitrate, and 2, whether such an agreement complies with the formal requirements of the lex arbitrae, and if it is different, the law governing the arbitration agreement. A second common challenge that we see is whether the parties to the dispute are the same as the parties to the arbitration agreement. Oftentimes, arbitrators may need to determine who the parties bound by the agreement are and whether a third party not designated in the original agreement is nevertheless bound by it. The general principle is that an arbitration agreement binds only the parties who have originally agreed to it. And as a consequence, third parties are typically not bound by arbitration agreements. That being said, a third party may be bound by an arbitration agreement in certain circumstances. If, for example, it is an assignee, a successor in interest, a guarantor, and so on. And this often depends on the facts of the case and the applicable legal norms governing the extension of the arbitration agreement to third parties. A third common challenge we see is whether the subject matter of the dispute falls within the scope of the arbitration agreement. Arbitrators may determine whether disputes arising between the parties fall within the substantive scope of the arbitration agreement. If it appears that certain matters or disputes are excluded from the scope of the arbitration agreement, arbitrators will consider whether to decline jurisdiction to decide on such matters or disputes. Finally, a fourth challenge that we often encounter is whether the arbitrators have certain necessary powers. Now, we often see disputes arise as to what powers have been given to arbitrators. In such cases, jurisdictional challenges are directed against arbitrators' exercise of a particular procedural power. For example, imposing sanctions for failure to produce documents, granting interest, or awarding interim relief. Now, any lack of powers may be cured by agreement of the parties. However, such an agreement may be limited by any overriding mandatory provisions of the applicable law. Now, as discussed, jurisdictional issues are raised at the outset in both investment and commercial arbitration, but how these are resolved can often differ based on the context. In investor-state arbitration, oftentimes we will have a bifurcated proceeding, which results in a dedicated jurisdictional phase and a dedicated merits phase, each of which are essentially akin to their own mini arbitrations, if you see these play out. In commercial arbitration, jurisdictional issues can play out in a number of different ways. It's a bit of a mixed bag. Certain institutions may address jurisdictional challenges themselves at the threshold of their institutional court, for example. The International Chamber of Commerce's court will do a prima facie analysis before tossing the issue to the tribunal for adjudication. Other institutions, for example, the London Court of International Arbitration, will reserve these challenges for the tribunal once it's constituted. And a tribunal may also reserve these issues for final determination with the merits at the end of the proceedings if the jurisdictional and merits issues are intertwined. In short, jurisdictional issues, while raised at the outset of the arbitration to preserve these objections, are not always resolved at the outset of the proceedings. And I'll pass it to Paul for discussion of consolidation and joinder issues.
Paul.
Yeah,
Paul, sorry.
Sure.
Before, let me kick off some questions just to
definitely
to prime the pump, so to speak. In both of your question for the both of you, sort of anecdotally, how often do you see jurisdictional issues bifurcated in international arbitration and including investment treaty arbitration? And do you see that is there a difference between the two in your experience, or does that happen a lot, or is that fairly unusual? Do you have a kind of a rough breakdown?
Sure. And I do think before we jump into other topics, there's a lot in what Carla said that we can maybe unpack a little bit. To your question, Eric, there is a difference in my experience, and Carla's may differ between investor-state arbitration and commercial arbitration, and certainly a difference as well when you get to domestic arbitration. In investor-state, I'd say the default is that you usually have a bifurcated proceeding. Certainly not, universally so, but very often the questions relating to jurisdiction are often felt to be segregable enough that they can be dealt with in a preliminary stage, because they get to things like, was there a covered investment made under the treaty? Things that are often, distinct enough from the underlying merits of whether or not, the state breached its obligations. And I think there probably is also an element that adds to this tendency that, because there are sovereign interests involved, the notion that you would continue to exercise jurisdiction throughout the proceedings to reserve the issues to the end, is maybe a little bit more of a sensitive topic than, when you get to commercial arbitration. In commercial arbitration, I'd say that, if I look back at my cases, it maybe is roughly about a 50-50 split as to whether you get those issues bifurcated or not. Very often, they'll actually be adjudicated alongside the merits, and really kind of the gravamen of the tribunal's, considerations here is this likely to make the proceedings more efficient? Meaning, are the issues to be resolved in the jurisdictional question distinct enough from the underlying issue on the merits that you're actually going to save time and costs, by adjudicating those first and dismissing the arbitration if there is not jurisdiction? Where those questions are deeply intertwined, you're often not going to get bifurcation, because it's pretty universally understood that bifurcation will add to the complexity and duration of the arbitration, and very often it's the case that jurisdiction may resolve only some of the claims or some of the parties, not the entire dispute. So I do really think there's a distinction there, and it really is bound up in what the particular nature of the dispute is. So I've had cases where we've had dedicated jurisdictional jurisdictional phases, some of which successfully disposed of the dispute, many of which maybe disposed only of them in part. But a lot of cases where, after briefing it, the tribunal said, no, we think it makes sense to consider these alongside the merits because they're so intertwined.
Thank you so much for that, Paul, and for the question. Are there perhaps any questions from our mentees? Anything you want to ask at this stage? Okay, then let's continue this on. When we think about the challenges, I think another piece that comes to mind is, how are these types of challenges defended? Who is bringing them, and who has the kind of the burden to make the case? So I'm sure you all will delve a little bit into some of those details, but sometimes it may be surprising to know that, or what's your experience with which party is bringing which types of these challenges to the arbitrator or the panel?
Sure. I think as a practical matter, particularly when it comes to jurisdiction, most often it's the respondent. And for a very simple reason, because the claimant who brought the claim, there in arbitration is the one kind of advancing this dispute, and it's the respondent who's attempting to defeat the claims that has an interest in getting the case kicked. Now, that's not always the case, and this actually ties into one of the things I wanted to discuss a little bit, unpacking from some of the stuff Carla said, which is that sometimes these issues actually arise in court before you get to arbitration, because it can be the case that a party who is bound by an arbitration agreement, or arguably bound by one, decides at the time of the dispute that for whatever reason they'd rather run into court. And the question of how the court handles this really varies from jurisdiction to jurisdiction. And within the United States, there's actually some variance within the circuits depending on what the nature of the dispute is. So in the Ninth Circuit, for example, there's a distinction drawn between questions that attack jurisdiction based on the validity of the contractual agreement to arbitrate versus attacks based on a defect of formation. And so, to give an example, if you're arguing that the arbitration clause is void because it was somehow fraudulently induced, rendering the contract voidable, that's something that's really going to generally go to validity. And that's something that usually, assuming that you've incorporated one of the major institutional rules, is felt to be delegated to the tribunal. If the argument is, wait a minute, I never signed a contract, this was forged, that's something that the courts look at as a fundamental question of formation. And so if it's before them, they'll generally consider themselves to have the power to determine, in the first instance, whether there was such a fundamental defect that there's not even arguably an agreement that exists. So it can be the case sometimes that the claimant with the claim comes into court and they're in the position of arguing that there's no jurisdiction. And if that is, based on an argument of validity that the court refers, to the tribunal, you can see how in that case, the claimant is going to want to be preserving the jurisdictional challenge. So they'll raise that at the outset. Whether or not it gets adjudicated at the outset, they're going to want to be on record preserving that jurisdictional dispute all the way until they get back out of arbitration and they potentially want to challenge the award. But, and there's also some instances where the claimant may advance a claim where they feel there's clear jurisdiction, and then the respondent advances a counterclaim, which, jurisdiction may be, questionable as to. It arises under a different contract or involves a different contracting party. So in that case, there may be jurisdictional issues raised by the claimant in response to counterclaims. I would note that that's really more of an issue in the commercial realm because, the cases where there's counterclaims by a sovereign state in the investor-state dispute arena, are far more rare, and it's a very kind of fuzzy area of the practice. So really, the jurisdictional challenges tend to be raised by claimants. Now, questions regarding things like jointer, what parties can be brought in and compelled to arbitrate, in consolidation, what cases can be brought within the same umbrella, those can and do get raised by either party, depending on how the case sort of unfolds. Carla, anything that you want to add to that based on your experience?
Yeah, definitely. I can speak to the commercial arbitration context. We discussed these issues of efficiency and speedy proceedings. Oftentimes it's the respondent that wants to slow this down and kind of, push the brakes on this. I can think of one instance where we had 4 identical supply agreements. They were form contracts. The only differing terms were, for example, maybe the governing law, various price and volume terms for the supply agreement. And the claimants in this case brought it as one arbitration. Obviously, the respondents wanting to slow this down argued that we should divide this into 4 separate arbitrations, 4 separate proceedings. There are 2 different governing laws. So you can see that, at least in the commercial arbitration context, as a means to kind of slow things down, maybe push the brakes. And it did not succeed in this context. Obviously, the arbitrator wanted one consolidated proceeding, but that'll be something that's resolved, for example, in the case of the ICC, at the level of the ICC court. It may be thrown back to the arbitrator for some discussion. There may be some brief letter briefing on that point, but not the kind of dedicated bifurcation, dedicated jurisdictional merits phases you may see in investor-state arbitration.
And Carla raises an interesting point here, which is, very often these things, get ultimately resolved by the tribunal, but there are certain institutions that in certain cases may actually resolve them at the institutional court level. So as she mentioned, the ICC has provisions in its rules that, permit in certain circumstances, the court to evaluate on a preliminary basis, any challenges to, jurisdiction or, the scope of the dispute before the tribunal. The way that's done is generally, as she said, a prima facie sort of first look basis. And if they're, content that there's, a substantial argument that an agreement may exist that encompasses the dispute, generally then they give it to the tribunal for further resolution. It's really the extreme outlier cases where there just seems to be no real, basis to argue that this dispute, can be heard by this tribunal, that they'll toss it at the court level. The Dubai International Arbitration Center has, similar processes. In fact, just recently, I was embroiled in a fairly long dispute with the respondent in the case at the court level before the tribunal was even constituted. So there are times where these kind of disputes can play out initially, at least in sort of it's almost akin to like a motion to dismiss. The way you might think about it in US parlance is that what you're looking at is just, is there a prima facie argument based on the pleadings? If yes, it goes forward. If not, it gets tossed.
Mm-hmm. If I can ask another question to both of you, when you are instructed now in a case, you're representing your client and you're thinking about the full proceedings, where do you think most of your time will be dedicated? Is it preliminary issues? Is it a middle section? Is it an end? And maybe you can also give a little bit of just a little bit of an overview to to all the participants here. How often do your cases settle? If they are settling, at what stage? Maybe just a few words on that to put it in perspective, how important these preliminary issues are and where they sit within the life cycle of a proceeding.
Sure. Carla, do you want to start?
Sure. I think, like many of these issues, it's very dependent on, is this investor state arbitration? Is this commercial arbitration? My first big matter as a junior associate was a major investor state arbitration case. I came in just as a jurisdictional word came in, granting jurisdiction, allowing us to move forward with the merits phase. And Paul, you were more in the trenches with this one, but I think that jurisdictional phase went on for a year between
it did, and there was a related dispute. In those cases, Carla's right. The jurisdictional phase was very long and it took up a lot of time, and in one of these cases at the outset, that really was a fundamental part of our, analysis and work as the claimant, because it involved some really intricate issues of secession under international law to the treaty of a predecessor state. And so there was really some questions there as to whether the claims would ultimately be viable. And so there, Carla, you're right. It was a long proceeding and it occupied a lot of the strategic efforts of the parties before we actually even got to the merits.
Okay.
Conversely, in my commercial cases, again, I've been doing a lot of ICC arbitration these past few years. You'll take it to the ICC court. They'll make a prima facie ruling, an analysis. It'll get thrown to the tribunal. Maybe the parties want some reconsideration there, but I mean, that could be a matter of a month, weeks, nothing like you see in these investor state arbitrations.
Yeah, and I'd say it really differs from case to case, and what party you're representing. So, certainly when you're on the respondent side, you're going to spend a lot of time at the outset of your work for the client, analyzing what the defenses are. And where there are some really credible arguments as to jurisdiction, that may actually occupy a fair amount of your time. I had a case in the last couple of years that was a post-transactional dispute having to do with something called an earnout, which is it's a mechanism that's used in a lot of transactions where the buyer wants to pay less for the assets, the seller wants to get more for them, and part of the way they hedge the difference between them is saying, well, let's agree to look at how the asset actually performs in the next 6 months, year, 5 years, and if it hits certain metrics, then you'll get additional money so that the purchase price actually becomes greater in the long run. As you can imagine, that frequently gives rise to disputes as to whether those metrics have been hit. And oftentimes, those involve accounting issues that the transactional agreements direct to a specific accounting dispute resolution process that can be referred to as arbitration or as expert determination, but it's sort of a carve out from the overall arbitration clause. And given the way that the seller in this case had handled the dispute negotiations up to this point, our view was that they really had made a mountain out of a molehill, in order to get leverage and try and shake out a negotiation and to get more than they were really entitled to. So in our view, this was really kind of procedurally improper, and a lot of the effort at the outset went into convincing the arbitrator that this stuff really needed to go to an accountant. That's what they had agreed on. This was the efficient way to handle this, and that at the end, if there were still some residual issues, we could come back to the arbitrator. And so, that's a case where really a lot of my strategic work at the outset was all about, jurisdiction and the scope of arbitral authority. I will say that most of the time, your efforts are spent much more on, the merits of the claims themselves and trying to figure out, what has legs, what doesn't. To sort of segue to your second question, Ghada, about settlement, while I think you tend to see a little bit less frequent settlements in the arbitral context, particularly in international arbitration, than you would in the kind of litigations that our firm tends to handle, which tend to be very big, very sprawling, take a long time, and often lead to settlement just because of the glare of public scrutiny and the extreme amount of financial risk. Oftentimes, arbitrations which are more confidential, oftentimes are happening between parties that have long-term relationships that they may want to preserve after the dispute is gone. All of those things, mean that there's a different sort of settlement calculus often in these sort of disputes. I'd say that probably over time, I'd say maybe 2/3 of my disputes have ended up settling, but very interestingly, some of those have actually happened after there's been a final award in the arbitration. Because as you know, you get an award, if the person doesn't want to pay it, that's not the end of the story. You have to figure out where to enforce it. You have to go into court, to get it enforced. And if there's a potential that, that the award debtor, might not have the resources to fulfill the award and could be pushed into insolvency, and this has happened to me, it raises some real strategic questions about what are the client's business goals and how do you realize them, in a way that actually gets them something as opposed to gets them picking over the pieces of a now bankrupt entity. And that can result in some really interesting settlement strategies and dynamics. I had one case that was very much like that, where we had an award, but ultimately the other side said, look, you can push this in court, but we're never going to be able to pay this. So let's figure out a way to resolve this. And we ended up negotiating a very interesting suite of agreements that involved sharing of intellectual property in different territories around the globe, and some issues over control over a brand that arguably ended up with a much better result for our client than they would have gotten if we had just tried to get the monetary award paid. So all that's to say that there's frequent settlements, but it's not necessarily always midstream, in the arbitration. Sometimes it's actually after the arbitration is concluded.
Okay, I think that's excellent. Just context and really grounding the practice of arbitration, especially commercial arbitration, within the businesses, the parties, and their what's happening for the parties. They're obviously in the business of their respective businesses. They're not in the business of arbitration. And to be able to place that in the context, I think is so critical for practitioners who are in this practice, and to constantly keep that in vizier. So again, let me go back. We'll check in with our mentees if anyone wants to even come on screen, and if you want to ask any questions about what you've heard so far, maybe, and don't be shy. This is an excellent forum for you to be able to ask your questions and get inputs from the experts.
Ghada, can I jump in? And both you, Paul and Carla, kind of made me think about sort of these jurisdictional and consolidation type issues as well, especially from the respondent side. And I thought it might be useful to make this point to the mentees, is that, jurisdictional type issues are so they're so fraught because they're claim killers, right? Like they're threshold issues, they're claim killers. Everybody gets really worked up about it, but I feel that sometimes on the respondent side, just because you can doesn't mean you should. And there's very often, at least in my experience, working on respondent side, um, sometimes there's a bigger there's a business calculus behind that. So to take Carla's example of four claims that are brought together, that are attempted to be brought together as a consolidated set, the respondent, there's an obvious play here, which is to try to defeat that and have them brought separately. But it's not, there's a business calculus, there's a budget calculus, and I think that to be a really value added counselor, you don't just sort of necessarily say, wow, okay, they're bringing these just consolidated, let's just oppose that just because we can, because it's the obvious chess move. And a lot of times maybe it makes sense to maybe it's just too expensive to have 3 times 4 12 arbitrators dealing with 4 separate defending 4 separate claims. There's all sorts of issues that pop up. They're budget issues, they're strategic issues. Maybe it does make sense to put all the eggs in one basket and just dispose of it because there's a finality type issue, like let's just get this over with and then move on with a business relationship or whatnot. So the bigger point I guess in making is that a lot of these issues with jurisdiction, but other stuff as well, there's always this sort of interplay of like, yeah, there's a sort of this narrow legal strategy, but lawyers tend to get really sort of focused on the legal aspect of it and then getting lost in the sauce and not pulling back and saying like, okay, what's the how does this advance our overall strategy? Does this actually make sense? And I mean, I see it all the time. I feel like when I'm on claimant side, I see these things kind of the opposing counsel just throwing stuff up that doesn't really quite make sense. I think I don't think they're serving their clients very well. So there's a lot more at play than just sort of narrowly focusing on, oh, okay, here's a consolidated claim. Let's just break it apart just because that's, it's there, and we can just make life miserable for the other side. So that's just a, small comment, sort of practice comment, I guess, that it's useful to kind of take a step back and pull back the aperture and always kind of look at these issues more holistically than just this narrow issue of, hey, do we have an argument against consolidation, or hey, do we have an argument against this or that? And then kind of pulling back and saying, hey, does this even make sense to oppose or to do this or to do that?
It's a really good point, Eric. And one of the things to think about in this context, if you're the respondent, is if you defeat jurisdiction, what do you think happens next? Well, you end up in court. And is that necessarily going to be better for you when it's all public, and you're subjected, if it's in the US, to much more extensive discovery potentially and, more expensive proceedings? Not necessarily. And I will say, very often some of the biggest dynamics that I've seen in terms of, how aggressively, folks on the respondent side, throw up arguments on jurisdiction, joinder, consolidation, and even merits arguments that, may seem odd or just not have a lot of, cogency or teeth to them, has to do with the nature of the respondent and the claims. If you've got a respondent where this is kind of an existential dispute for them, they're going to be much more likely to throw out everything they can, because really what they're looking for is some leverage. A perfect example is very often in the life sciences context, you have cases where you've got a big multinational pharma company that goes into an alliance with a smaller startup that has some great ideas for a drug. And disputes can arise down the line on whether the pipeline of funding is pulled because the research doesn't seem to be going anywhere, or the market is now flooded with competitors. And if that large company that the alliance partner is partnered with is looking to pull the plug, that can be the end of the minority company. And in those sort of cases, respondents are looking for any ground to stand on to get some kind of leverage to negotiate a reasonable exit that doesn't essentially end up folding their business. Now, when you've got more parity between the parties and oftentimes longer term interest, whether it's supply interest, joint venture relationships, in those cases you tend to find much more pragmatism in the way the parties go about addressing these kind of issues. So this brings it back to the point that Ghada underscored, which is all of this exists in the context of the client's businesses. And understanding the unique nature of how they're situated with respect to this dispute and this opponent and what their real goals are is really going to drive how you look at the strategy, whichever side you're on.
Okay, well, I want to thank you for that masterclass there. Honestly, that was really, really spot on. I see a
I've got a
hand up.
quick question if I can
Christopher,
jump
if you
in.
could
Yeah,
jump in.
sure. Well, I was just kind of wondering, Paul and Carla, thank you for your time. And sorry, my camera's not working, otherwise I'd turned it on. Regarding kind of the past 10 minutes or so conversation where a lot of it's been focused on ultimately really business decisions for the various companies themselves. How often do you find yourselves raising those issues proactively versus the company that you might be representing raising them first? Do you feel like it's something you are more often responsible for preemptively raising and bringing to the client's attention, or do you often find that the client's being like, hey, wait a second, is this going to be a good business decision if we continue down this road?
I mean, I think Eric raised a,
yeah, please.
Just briefly, Eric raised a great point. Oftentimes, as lawyers, we can be a little fixated on the legal issues of a particular dispute. We want to contest jurisdiction here. We want to have 4 separate arbitrations. We want to draw this out. What's the actual business thinking there? Is that going to provide some leverage for negotiations or settlement? Or is this just going to draw out a long dispute? And, in a case where you have a long-term relationship between, for example, a supplier and a customer, is that going to completely ruin that relationship where, after everything has been burned to the ground after the arbitration proceedings, you've impacted the fundamental business of your client? So I've seen it been raised by attorneys and, in-house counsel alike, but I do tend to agree that as lawyers, we have to be aware of that and oftentimes may have blinders on when it comes to, the actual commercial dealings of a particular client.
So I'll say that the lawyers that clients tend to value the most and come back to the most are the ones that get the business thinking and can raise those things independently. Carla and I share a mentor who's actually deeply involved in Cal Arb and is on the board, named Steve Smith. And I've always thought that the legal community lost a great transactional lawyer when Steve went into to international disputes, because one of the things that struck me right in my first year or two was just how sophisticated he was in his business thinking, and how not only did he have a strategy for the dispute itself, but all of that was in the context of trying to game out what the off-roads from the dispute were to try and get the client what it wanted. And so this has been something that's been sort of beaten into my head from the time I was a junior attorney. If you want to establish client relationships that have legs and really are going to form long-standing bonds, you have to be looking out for more than just the tactics of the dispute, and how you win it. You have to be looking at, what is really in the client's best interest. And, we have a business development lawyer in Jones Day, a client services, lawyer who is fond of talking about the stages to developing a client relationship. And you start as someone they go to with a question. Then you become someone that they go to, with more than a question, but a problem. And ultimately, the deepest client relationships are ones where you're a trusted advisor to them. Because think about it, these lawyers, at clients and the business people at clients, they have people that they answer to themselves, their bosses, their shareholders. The best thing you can do for them, is help them look good. And part of that is being able to issue spot things that sometimes they may not be able to because they're closer to the facts, closer to the business, or closer to the dispute. So, to answer your question, you're much better off if you're the one who are raising these questions to the client than vice versa. It's better to say, okay, but here's things to think about. What do you really want? Where's your business strategy going? Because these decisions you make can have X, Y, and Z impacts, than to have the client coming back to you and saying, well, wait a minute, if we do that, isn't that going to be really risky and expensive? One fosters, a real trusting relationship. The other, is indicative of just being a tactician there, trying to win a case for them.
Mm-hmm. Oh, excellent. And having been in those in-house counsel shoes, everything that I've heard just resonates so much. I was in-house counsel in a company that wasn't particularly litigious, and for them, reputation and relationships with their business partners was paramount. But we found ourselves in that position where we were, going into a dispute, and we had very big decisions to make. So we ended up really having a kind of over a weekend strategy session where we pulled in key people from the business, the in-house team, as well as our external counsel. And we really hammered that out. And we ended the session with a document that was signed off by our management. These are our goals. This is what we want to achieve. And, we got those early inputs, and we kept going back to that document and to see were there some off-ramps. That case, I always said over and over, it should have settled at some point, but there wasn't the willingness from either side. It wasn't going to come from us, and it did come from the other. But again, that's another story for another day. But just for the many of you that are on this call today, your career trajectory may be that you're in the in-house counsel shoes. And that interplay between, you're at that nexus, what your business needs. You're also the lawyer, and you're working with the external counsel, and that relationship is also, very, very important to these proceedings.
Yeah, and I know we had talked, Ghada, in planning for this about trying to, leave some time to just talk a little bit, more broadly about, our career paths, how we got here, and questions that, folks may have about that. Carla and I chatted about this, and we're happy to talk about, preliminary issues as long as you want, but we're also happy to talk, about other things and that might be of interest. And I see we've got another hand raised here.
Yes, exactly. We'll take Lundi's question, and yes, and then let's segue into just some more general background on careers and how you got to where you are, and all of that good stuff. Lundi, the floor is yours.
Hi, everyone. Am I audible?
Yes.
Yes.
Okay. Just in light of everything that has been said, my question is really directed to both speakers. So, how important is knowledge of procedural rules for the arbitration practitioner, for the practitioner?
Carla, do you want to take that first?
Sorry, how important is knowledge of
our knowledge of the procedural rules?
It's key. I mean, in terms of strategy from the outset, you can very quickly distinguish yourself as a junior associate. And this is some advice I have for any potential people going to this field early on in their careers, by having an intense knowledge of the procedural rules, whether it's jurisdictional issues from the outset, preliminary things like that. That is a very, very easy way to kind of shine very early on in your career.
And I'd echo that. I mean, if you don't know what the rules are, you can't, figure out how you can, work within them to, tailor the procedures to your client's goals and strategy. The starting point for any of those kind of strategic maneuvers is understanding the framework that you're working within. So it's absolutely crucial. I will say one of the things that you'll find in international arbitration generally is that across all the major arbitral institutions, there's a lot of flexibility built into their rules. There's a lot of commonality to the way that the sets of rules work. So it doesn't take a lot to understand the basic framework. The other thing that you have to know, though, is not just those rules, which leave a lot of room to work, but what are the sort of norms, the soft norms that exist within the practice, things that the arbitral tribunal is going to be coming to the case with, in their mind as the normal and appropriate way for things to be done, because that's equally as important. One of the things that you often see in international arbitration when you have a US litigator that really doesn't have experience in international arbitration coming in is they bring a litigation strategy where they're talking about depositions and interrogatories and things that are really foreign to the practice of international arbitration, and the tribunals generally don't have much patience for. So it's not just knowing the rules themselves, it's knowing what the norm and common practices are. And once you know those, you can use the flexibility that's inherent in arbitration, to craft a strategy that is most advantageous to your client and its goals.
And you see that with a lot of the big law firms, which are from common law countries like the UK, the US, where you do have something like robust discovery. And it's not really a thing in arbitration, but I mean, in my practice, I've seen it increasingly become so, whether that's for the first time I'm experiencing, for example, depositions in my arbitrations. That's typically unheard of. So, I mean, you really have to consider, why did we choose arbitration in the first place? There are certain efficiencies built in, a certain, preference for that from clients and lawyers alike. So, having knowledge of these norms is kind of key. And then, they'll vary procedural rule by procedural rule, but there are certain bedrock principles that are key to any case.
And the reverse is true too. If you're somebody who tends to practice internationally, in international arbitral forums, as I think both Carla and I are, when you go into a US domestic arbitration, you have to understand that this is a different process in a different world with different expectations. Very often the appointed arbitrators, if you're, for example, under the JAMS rules, are going to be retired judges, whose framework and expectations are different than if you're in front of an international tribunal, composed of primarily international practitioners. So you have to know and understand the forum you're in, and the differences that arise, out of that, because they really can be substantial.
Okay, well, how about that in the remaining time that we have? Let's hear a little bit more about the two of you and your career trajectories, your path in arbitration.
I'll let you start, Carla.
Sure. I came into my summer at Jones Day, this was 2016, convinced I wanted to be a transactional attorney. So I had quite the 180 here. After a few weeks, I realized I wanted to do something more, adversarial. I enjoyed the rhetorical aspects of litigation. I knew I wanted something with some sort of an international nexus to it. And at one of our summer events, I met Paul. He told me what he did, and I said, hey, that is exactly what I want to do. And the rest is kind of history. I can't say I had any substantial experience with international arbitration beforehand. I took a 1-unit seminar in law school, and that was the extent of it. I didn't take any international law classes. That being said, many of the skills you acquire in law school will be relevant, whether it's, oral advocacy, research, legal writing. The research might be a little different, the sources may be a little different, but it's a lot of common principles that definitely overlap between more traditional US litigation and international arbitration, maybe more so than you would think. And I started on very big investor state cases. Paul mentioned our mentor, Steve, went into more of his commercial arbitration matters. That's still kind of the bread and butter of what I do these days. I've been doing more so domestic arbitrations this past year or so, but the international arbitrations definitely pop up here and there. And yeah, it was not something I had planned for. I thought I would be doing more of a traditional US litigation practice in my career, but just as a result of, you know, this vast global disputes group that we have at the firm that does really have a nice breadth of international work, I kind of fell into international arbitration, and you know, the rest is history. I've had no regrets since.
You know, so when I went to law school, I knew that whatever I did after law school, I wanted it to have a substantial international cross-border, you know, nexus or characteristic to it. I didn't really know exactly what that looked like, but all of my electives, you know, with few exceptions, were always international something, foreign something, cross-border, transnational, whatever. And I came to Jones Day for a couple of reasons. One is because, you know, of its global footprint and the nature of its client base, which is global. I thought that there was a maximal opportunity, regardless of what specific practice I was in, to have some interesting cross-border aspects to what I did. And in particular, the San Francisco office I knew had been deeply involved in some really interesting complex litigation under something called the Alien Tort Statute, which, you know, allows claims brought under international law to be heard in U.S. courts. At the time, in the, you know, the 2000s, it was very active before a Supreme Court decision or two kind of reined it in. And so I thought, well, this is a firm that gives me some real opportunities to explore this. I still didn't really have a vision of exactly what that meant. You know, I thought maybe I'd be doing antitrust work, knowing just from my law school practice that there were a lot of real interesting issues at the intersection of non-market economies and market economies. When I got here, the global disputes practice had just been stood up, reorganized from practices that had always been here, but sort of structured in a way that made strategic sense for our clients' growing needs. And as a part of that, Steve Smith, our mentor, had come in during the period between my summer associateship and my associateship as a part of growing that practice. And very quickly, you know, he invited me to do some work for him. And I realized that this is exactly what I had been searching for. And, you know, through Steve, as well as through numerous colleagues in our DC, London, you know, New York, you know, Singapore and Dubai offices, I've had, you know, the good fortune of being able to work on a lot of really interesting international disputes and trade matters throughout my career. You know, so I'd say that there's an element of, you know, sort of knowing what your preferences are and doing what you can to open those doors and maximize them. But there's always an element of, you know, kind of dumb luck. You know, I happened to be here in the right place at the right time as our practice was growing and reforming, as Steve came in as a part of that. And, you know, I was able, as a result, to get in kind of on a ground floor, you know, for some of these expanding practices in our firm. So, you know, the lesson that I take away from this is that, you know, the best thing you can do is, you know, keep an open mind, you know, do what you can to maximize, you know, the options that are available to you and to look for things that will meet your preferences, but always be alert to when that unexpected knock on the door happens, you know, that can change your career trajectory. Because I think, as Carla described, for both me and for her, you know, that knock came and it's taken us in places that, you know, we didn't imagine when we were, you know, sitting in our law school classes.
Well, I can't thank the two of you enough for all of your, well, walking us through all of the, you know, the heavy procedural issues that happen at the outset of arbitrations, but also imparting a lot of wisdom generally, and as to these important career decisions. And I'm sure that our mentees are going to take that and really ponder it and think about it. And to the extent that you have questions, you know, please do feel free to reach out to Paul and Carla. They have made themselves available in this context, and they look forward to hearing from you as well. I think the only thing left to do after that wonderful presentation is to really thank our speakers and to, yeah, thank all of you for attending.
Thanks. Certainly my pleasure, and absolutely don't hesitate to reach out.
Likewise. Thank you, everyone.
Appreciate
Thank you,
it.
Paul and Carla.
Okay,
Thank
we'll
you.
go ahead and adjourn. We'll end the recording.